and knowing how and when to engage with PDPO. I'll be telling you more about PDPO later on. So why privacy and AI governance matters. So since this is a computing class, I'm wondering how many people have engaged with AI beyond what you've studied in class. Anyone? Whether the product that you've developed, you've used, has anyone used any AI product? I think I'm just going to pick if I'm not willing to respond. Yes, let it black. Say your name and the respond. Have you used any AI product? Sorry? Which one? That's different. Okay, you should be more before. The next thing is that, have you used any AI product developed one? Which one? You tell me, this is the computing class, yeah, lawyer. Which one? You what? You did. What's what? There you're saying it. Okay, so AI runs on data. We all know that. It's its foundation. Whether you're using it, like you say, chatbots, recommendation engines, facial recognition, and others. Now, how many people here have noticed that as part of their Gmail of late, when you're typing in an email, it prompts or gives you suggestions on how it should be completed? Have you noted that? So all that is part of AI. Then when you're on the streaming platforms, even by the way, on YouTube, you know the recommended videos that come up after you've watched a video. So that is also part of AI based on that. So data fuels it, whether for the different users that we've just talked about, but it's also very key for us to understand that any person who is either you're developing a product or you're using, as long as you're using those particular platforms with great data, comes great responsibility. ChatGPT, whether you're doing your coursework, whether you're asking a medical question, or you're doing anything with that much information, because if you don't give them that information, then it cannot be able to reason as a human. But before we get into too much of that, we'll start with the journey of understanding data protection and privacy. So data protection and privacy started all the way globally in 1948, what we call the Universal Declaration of Human Rights. Why it came about is that data played a very big role in the world before then. As far back as so from as far back as people who believe in the Bible, what happened? What we call before Christmas. Does anyone know what happened? What led to that? Okay, a couple moved out of town to do what? The gentleman in blue. Okay. The gentleman in blue. Are you a Christian? Or do you celebrate Christianity? You don't? Interesting. Yes. What happened to the couple that moved out of town? That led to Christmas. What was the reason? People don't even read the Bible. So what happened is that they needed to go out because they needed to go for a census. They were being counted. So data protection goes as far back as that because governments were collecting data and they needed to understand their citizens for planning. Now this greatly changed just before the two world wars, where that data which was being collected by certain actors was being misused. People of a particular race, religion, ethnicity were being targeted, and what led to some of the wars, specifically World War I and II. So after World War II, the different states came together and they came up with what is called the Universal Declaration of Human Rights, whereby one of the rights which are recognized is the right to privacy, that even if your government, as long as you collect any data about individuals, whether it's through a census or any government activity or even private sector, you needed to ensure the privacy of that particular individual. So that's how it came up in 1948, what we call the Universal Declaration of Human Rights. But the very first data protection and privacy law, a comprehensive one, it was in Western Europe. And it was mainly in Germany and Sweden. Those are the first countries in the world to come up with a Data Protection and Privacy Act. Then after that, in Uganda, we had our own right to privacy in the 1995 Constitution, mirroring what was in the 1948 Universal Declaration of Human Rights. Under Article 27 in Uganda, the right to privacy was recognized. So not much happened after that because it only provided for the right. Happened, but between 2006 and 2016, we started coming up with sectoral laws that were recognizing data protection in the sense of the right to confidentiality. We have the Regulation of Interception of Communications Act, whereby if anyone is to listen into your conversations, get a copy of what you are saying, or any of your transactions, they needed to fulfill particular conditions, and they get a court order for them to be able to do that. So in other words, infringing on your right to privacy, but giving you protection within that particular law. Then in 2011, 3 laws that we call the cyber laws were enacted by Parliament. The Electronic Transactions Act that deals with transacting online, communicating online, and also providing services where you needed to follow particular consumer protection provisions therein, which also included your information. Then signatures is where, does anyone know what the difference of electronic signature is from that of the digital signature? Anyone? Who can attempt? I don't know whether she's a Hajat or a nun. Please attempt. She could be a sister. Yes, what's the difference between an electronic signature? This is a university class, but people don't want to talk. You're all so timid. Is your lecturer too tough? Is it too tough? It could be very tough. Yes, Hajat. What's the difference? Do you have a signature? You don't? I'm starting to get concerned. You don't even have a signature? The gentleman here, do you know the difference between an electronic signature and digital? Like? Thank you. So the electronic signature, actually starting from a signature, the purpose of a signature is to distinguish you from another person and to also show that it is you and not any other person. Now, the electronic one, you know, it can be as simple as your email address. Because you have the password, you send someone an email, they are able to tell it is you and not someone else. On the other hand, a digital signature is that it has more capabilities to it, whereby there is underlying infrastructure when you have a third party that will attest and say that it is Baker who signed and not any other person. So that is the difference. But before that person attests, they need to collect certain information behind that. Your national ID, other details. So why it's brought up here in privacy is that a lot of information is collected and the law requires that it should be protected. Computer Misuse Act penalizes anyone who misuses computer spaces. Employment Act, a lot of information is collected, either part of background checks when you're being employed, or even as part of your employment relationship, the contracts, and it requires confidentiality of such information as well. But what changed in 2015 is that now Uganda got a national ID, whereby every citizen and resident, you're required to get one And you're given a number after a lot of information is being collected about you. And it's also tagged to your lineage as well. So a number of provisions were brought about. So if an individual was dissatisfied or concerned about the confidentiality or privacy of their information, they needed to know each and every of those laws and who is implementing them in government to raise their complaints, which is not easy. So Uganda joined the rest of the world, whereby in 2018, Parliament passed the Data Protection and Privacy Act, which was assented to by His Excellency, the President of Uganda, in 2019. It created a comprehensive regulatory environment whereby all those privacy issues that we've been talking about here and more were now covered in one law. And in 2021, the regulations which operationalized that act were passed, and the Personal Data Protection Office, where we come from, was established. That office is a government office that deals with regulating that collection through registering every person collecting your personal data. If you're dealing with anyone, first find out if they're registered with PDPO. You go to the PDPO website, pdpo.go.ug, and you search the register. If they are not registered, you can raise a complaint with us. Gilbert, is Makerere University registered? So even where you go, whether you go for leisure, those particular entities are required to register with PDPO. So the other work that PDPO does as well, it receives complaints, investigates them, and also audits these particular entities to assess their level of compliance. So now we're going to look at the key definitions in that law. For you to be able to understand this law, you need to know the definitions because we are going to use them as we go along. And they are very important in your journey around AI or anything to do with data, specifically personal data. So this law only deals with personal data. It's any information from which an individual can be identified. It's as simple as your name. We all have different names, but even where you may have a similar name, you know, there are other aspects from which you can be identified as an individual, such as your academic background. Even when you do group coursework, at the end of the day, you're given marks individually, isn't it? And even at graduation, you're given academic documents as an individual. Do they issue group degrees? Do they? The gentleman here, do they issue group degrees? So even your academic documents, that is personal data. This also includes what we call the identifiers, such as your mobile phone number, tax identification number, the NIN, that is also personal data. That includes your email as well, but also there's what we call the preferences. When you're on social media and you know you like a particular post or particular information about you of how long you visited the website, what we call the metadata, which page you visited. If a person gets all that information, they can be able to uniquely identify you, even including the IP address, because that IP address is what you use to connect to the internet. Now there is the static one, whereby it's a lot easier to know it was you, but then there are the dynamic ones, whereby they are shared amongst different people, especially where they are sharing a network. Now at that point where you had yours, and you use it whether to print, whether to connect to the internet, that is also termed as personal data. So the other is what we call the data subject. This just means the living individual from whom that information is collected. This law does not apply to people who are deceased. As long as you pass on, even if a person has your personal information now, that will be dealt by other laws that we call the estate laws. Someone cannot come in and say they've taken over this person's data. Since he's not around, they can exercise their rights. No. Neither does this law apply to information which is non-personal in nature, which includes companies. So this one is not covered in the law. Then the other party is what we call the data collector. Just means the person who actually collects the information. That person who will come to you, give you a form, or will give you a mobile application for you to be able to insert your data. The one who actually does the collection is the data collector. On the other hand, a controller means the person who determines the means and purposes for collection of that information. So the university will say, for this particular course, we need a person of, have even forgotten, they call them points. The person who got this so many points and weight, then they can be able to admit you. That makes the university the controller because it tells you which information you should submit. Then if you're developing any AI solution and you say, okay, you would like particular data sets, let's say education, health, and land-related matters, that makes you what we call a data controller. These definitions are very important because they determine which obligations are imposed on you by this particular law. A processor is different from the way you understand a data processor in the computing world. Here it just simply means that person who they don't determine the means and purposes or which data to collect and use, but the person who has determined and the one who has collected, they give that information to a data processor and they give them specific instructions on how they should process that data on their behalf. This does not include an employee because an employee, you process data on behalf of your employer, but you cannot be called data processor. Processing, on the other hand, in terms of data protection, means any operation on which that data is performed. This can include collection, can include alteration, organization, retrieval, use, or even dissemination. So it basically covers what we call the data life cycle. Does anyone know what the data life cycle is? Anyone? Who knows cradle to the grave? Did we come too early? Anyone who knows cradle to the grave? That phrase, anyone? The gentleman in the Joseph, you try. What do you think is the phrase cradle to the grave means? Oh, there are two. This one has nodded. The one at the back. To be honest with you, this is very concerning. Can you please liven up? Or we should use another language? Should we? Which language should we use to have this lecture? The lady in white. Do you have another language we can use? You can propose? Should we maintain English? Just laughing. Because you're all not being active. So in that law, what we've just talked about, the different personalities, the law really, what we've been talking about, if you're a controller, processor, or even a data subject, if you're to understand the Data Protection and Privacy Act, you need to understand the principles. Whether as a person who wants to understand the obligations, or even you as an individual, where your rights come from. So the law requires that when you collect data, you should make sure that you're accountable to the individuals from whom that data is collected. That accountability starts with registering with the office, that is PDPO, appointing the person in charge of compliance, the data protection officer, and the related matters. Then the other one is lawful. The law says when you collect this data and you're to use it, the processing we talked about, make sure that you have a lawful ground. These grounds are provided for in the law. Either you can use consent, but consent is not the only ground. Then the other one, if a government body, if your law requires you to use that particular data, then you can use that as your lawful ground. The other could be a contractual purpose. Someone can say, I need your data as a bank before they can issue a loan, they need to do background checks if you can be able to repay the loan. So that is for contractual purposes as well. Then there is medical purposes as well. If you go to a hospital, before you're given the treatment, they need to pick some information from you, among others. Then even where you have a lawful ground, the other principle is minimality. Make sure that you only collect data that is adequate, relevant and not excessive for that particular lawful ground. Then retention, retain that data only for that purpose for which you've identified for use. Even where you're already using the data or at the point of collection, make sure you have quality data, that it is complete, not misleading. And that's why you see those who may have renewed their national ID, you are given an opportunity for you to view the screen and confirm that the details you provided are actually correct. That is around the principle of quality. Transparency, the law says, before you collect any data, let the individuals know which information you're collecting. Who is collecting, what you're going to use it for, if you may share it with another person, how long you'll keep it, so that someone will be fully informed if they will be willing to give you their information. Last but not least is security. Make sure that you secure that data. Do you know what the CIA is? The triad in security? Anyone? What is the C? The lady at the back in the CIA? What is the C? Your neighbor can help you. Yes, it is you. Also looking. Unfortunately, your neighbor is a slab, so it has to be you. Can anyone try the I? Yes? Integrity, correct. Who can try the A? Yes? What is the A? Sorry? What did he say? I couldn't hear. What did he say? Agency. Then why are you laughing? Maybe you tell us what you know. Your neighbor can help us. What is the A? Yes, what is the A? Oh, help me. I'm not able to read. Accuracy. Thank you. So the CIA triad is the foundation. You remember how I've been telling you the foundation on data protection and privacy, they are the principles. The CIA is the foundation of information security. Let me, help me with your phone, please. Sorry. So I'm unable to open her phone. It requires a fingerprint or a password. This is the first principle of information security. So the C is confidentiality, that your data cannot be accessed by another person unless you granted them the access. So that is what we call confidentiality. I'm sure most of you have passwords on your phones. Then integrity is that whichever information you have cannot be changed unless that person has authorization. And availability, it's about backing up. So information security is around that, confidentiality of the information, but not only personal information, keeping it its integrity in the right form, and even where the data is lost, can actually be available, what we call availability. So we're now going to look at the ethics and regulatory considerations of Ugandan data sets. Remember, today's conversation is around AI, and the foundation of AI is data. So there are a number of sectors, whether health, education, or finance, or even agriculture, but each carries its own sensitivities regarding the data collected. For health, if there are patient records or genetic data, they are highly sensitive because someone is able to tell if a person is suffering from a particular condition, if they are being treated, or anything of that regard. So that is not information that should be readily available. Now, when you talk about education, it could be your grades or even what you've been awarded. Now, the challenge with it is that it can be able, if a person misuses the information, it can influence your opportunities. If a person has that particular record and it's part of a data set and it indicates that you failed a particular subject or you didn't earn a particular mark, then you can fail to get a particular opportunity. So whoever is collecting these data sets, they should ensure that the information is accurate and it is fair from whom it is collected. For agriculture, land ownership is very key. So if it shows that you don't own the land, or that if you had a lease, it expired, then it can definitely affect you. So the main things around this is around unrepresentative data, which can lead to unfair outcomes. I'll use an example of now so many people are using AI. If I go to a bank and I need to get a loan, or it could even be a money lender that uses these digital applications. So if they build that particular AI application whereby the data they tested was for people from Kampala because of their economic status, but it's being rolled out to people who are upcountry, it will not be representative of their economic status, which means it will unfairly give them results that do not speak to their situation. So the bigger question is our AI fair and equitable for all Ugandans, whereby people are well represented in that particular data set? Because remember, data set is just how you read, it's fed information, but if the information is on your particular segment, then it can be unfair to the people who are not represented. So what are the best practices for responsible AI development? Number one, data anonymization is very key. How you can do that? Number one, you need to remove the personal details, especially when you're training these particular large language models. You remove take out the names, the ID numbers, and even phone contacts. You can also hide the exact locations, such as GPS or home addresses, and you replace them with other identifiers. Then you can also mix and group the data. Why all this is being done is to make sure that a person cannot be identified as an individual, where you get these data sets and you're training these particular large language models or other AI solutions that you may have. That way, you can be able to use the data, but whereby the individuals are not, cannot be identified from such. So the other one is around consent management. But I need to highlight that consent is not the only ground that you can rely on if you're using personal data. Which other grounds did we talk about that you can rely on, the legal grounds to use the data? Anyone? The lady in brown, which other grounds? Yes, which other grounds did we talk about? Let's get someone to first help us summarize what we've been talking about. This will help us. Yes, the gentleman here. What have we been talking about? If the class ended here and they tell us that let's leave, and someone said, what were those people talking about? What will you tell that person? Try to be a bit more audible. Hmm.
We're talking about also principles of data protection privacy. We talked about accountability, inequality, and also bringing together.
It's okay, you can stop there. Clearly, you've been attentive and even taking notes. Let's get another person who can help us understand. We have another Hajat. At least this one must be a Hajat. What have we been talking about? Yes, please. And something which is not on the slide. What have we been talking about?
We talked about
Can you hear her? People at that side, can you hear what she's saying? They can't hear you.
We talked about Uganda's data protection and privacy legal framework, whereby he mentioned the acts according to the years that we have seen brought in. Like we have the sectoral privacy laws, talked about each act individually, and then we also talked about the key definition for protection. Like
Okay, thank you. I'm going to get another person to help us summarize now, not just what you've been noting down, but what you've understood. Yes, the gentleman here in a jacket, in a brown jacket.
We talked about how to secure data.
And how do you secure it?
And we talked about government making it generic. Information that was there. I talked about maybe the person is on Kumba Avenue. They're just making it generic. And then also the encrypting that, putting it in a format.
Okay, thank you. The lady in red. Can you hear her at the front? Try to be more audible. Okay, thank you. I can see people are more interested in the technical part, but at least you're following. Okay, so consent management is one of the areas where consent is very key. Before you take people's data sets, you need to get their consent for starters. So, and consent is defined by the Data Protection and Privacy Act, which is broken down. It should be informed. We talked about transparency as one of the principles, letting the person know what information you're taking, what you'll use it for, and who is taking it anyway. Have you hired a person to do it on your behalf? They should be able to inform those individuals. And it should also be very specific and granular, that if you're to use it for a particular function, tell that individual, want to do ABCD. If it will be something else, then you need to obtain fresh consent. And it should be freely given. They shouldn't be coerced. In the context of AI, especially for secondary purposes, where you want to update your models and the rest, make sure that you obtain fresh consent, or that one which you're obtaining at the start should be well detailed to cover that. To help us understand what consent is, as defined in the law, there is a case of Shadia Naluvega versus Starbucks. So Shadia Naluvega was an employee of Starbucks, where she was working as a pump attendant. They asked her one evening to come back the following day when she's better dressed than she usually does, because they needed to take her picture for purposes which were not indicated to her. She begrudgingly refused, but because she needed her job, she just stand up. And later on, when she left about a year later, people started calling her that they can see her photo on billboards, social media, marketing products, and people are even asking her for money, saying she has money, because they believe they had paid her. So she took the company to court, and court had to determine whether Naluvega Shadia had actually given them the consent that we've just talked about here, that was informed, specific, freely given, and she could even have had an opportunity to withdraw it. Court said that they did not obtain the consent as defined in the law because it was implied, and yet the consent provided for in the Data Protection and Privacy Act in regard to collecting and using personal information should be expressed and very clear. So she was awarded damages of up to 5 million, and the company was found to have breached the Data Protection and Privacy Act. So when you're dealing with any information of individuals where consent is needed, you should be able to get consent as defined by the law. But I should quickly add, for use of personal data, it's not in all cases that you may need to use consent. I've already talked about those much earlier. So we're going to look at now AI, but real world case studies. There is this case of Facebook versus Cambridge Analytica. It was around, I think, 2015, 16, where there is a company called Cambridge Analytica. It entered into a partnership with Facebook, whereby it was harvesting people's information from social media, particularly Facebook. At that time, people are being told that if you signed up for that particular, they called it an experiment, then they could pay you money. People signed up, but then what they didn't know is that the information they're collecting about them, which pages you like on Facebook, people you interact with, the comments that you make, what you're talking about was being harvested for political purposes. That information was used to profile individuals, particularly in the United States, where people involved in the campaigning season started buying that information. So if someone was talking about Republicans, expressing their support to them, and anything to do with any political party in that regard, then they would target these people with particular adverts on messages of that particular political party, which heavily influenced the American election at the time. So the key lessons from this is that there was misuse of personal information because people thought were getting involved in an experiment or a study, and yet their information was used for something which was not known to them, their data sets. And then there was also manipulation of consent. It was not very clear to them what they are going to use it for. And of course, it eroded trust in that particular system. It affected that social media company, and so many people left as well. The other one is what we call the WorldCoin. WorldCoin is a company which is owned by OpenAI as part of the companies, the ChatGPT that you use, but they have an offshoot company. So this company is in innovation, and they wanted to come up with a unique form of signature. Remember the ones we talked about, the electronic signature and digital? What's the difference between an electronic signature and digital? Before I go into this case, we've talked about it. Yes, the lady in, I think it's pink. What's the difference? You came in late, but you try. You need to be audible if you are not audible. So anyway, in this particular case of WorldCoin, in Uganda, this company was working with another company where individuals were told that they would be given cryptocurrencies in exchange of their particular personal data biometric information. So they had something which looked like a circular ball that you would directly look into, scans your iris, captures that information, and then it takes it to be stored in Germany. So the individuals thought, well, I might as well give them as much information because they thought that it was free money. But in that particular process of it, they were using it to train their digital signature that they were planning to come up with. Where, if you need to log into an email account, unlock your laptop or anything, you don't need to put in any password. It just scans your iris because it already has that biometric information, and you're logged on. Now, the challenge with that is that in some parts of West Africa, because they are giving out money, it was mainly East Africa, West Africa, and some parts of Asia. Some people started getting goats and animals to be scanned by that particular machine to be given money. So the company was capturing so much information, thinking they're capturing for humans, but yet they had in their database thousands of goats and cows from West Africa. So here they decided to now continue improving their particular product, whereby they needed to capture more information from the individual. But the people who they were targeting to use that particular product were people in the Western capitals of the world, people in Europe and the US. So we had to stop them from continuing to collect that information because it was posing a privacy risk. Your biometric information, especially iris, cannot be easily changed. So if a person captures it and they misuse it, you'll be at a great risk. It's not like an electronic signature that you can change, but it's one that is actually attached to you as an individual. There were issues of consent because they had a very long privacy notice whereby they did indicate what they're going to use the information for. And of course, not many people read it. But when we pressed them, we saw that they had actually included it in something very small that wasn't even part of what they were giving the individuals, saying that they will be using your information for trial purposes as part of their data sets. So the other one, we'll look at engagement with PDPO. The office, like I indicated earlier, any person collecting your information, institution require them to be registered with the office. If they are not, raise a complaint. If you're to help them get registered, that is the process. It is done online. They complete forms 2 and 3. They are automated within the portal. Then you pay registration fees of 100,000. Now you register once, but that registration is renewed on an annual basis. Then it's submitted, reviewed by the office, and then you're issued a certificate of registration, and you form part of the public data protection register. How you can engage further with PDPO, we have a number of support services, training and awareness. We are conducting awareness, but training is more detailed, where we take you through the different areas of the law, the legal side, the technical side. We've developed a training curriculum that will have a foundational level, intermediate, and advanced, where someone can undertake the training in each of them and be given a certificate in these areas, but in more detail. The other is the consultation, project-specific, where we can give guidance, regulatory guidance on how you can comply with the law. We conduct audits to ensure that the law is well complied with. We give you support on guiding how that breach should be managed. Now, I'd included this last one, but I'm having second thoughts. For students and researchers, career development, we usually have internship opportunities at PDPO. But with the interactions we've had, it would be hard because you all seem so withdrawn. But anyway, there it is. So the law, the Data Protection and Privacy Act, has a number of offenses. Any person that doesn't comply with the law, and one of the scenarios, one, if you fail to register, I've talked about registration on at least 3 occasions in this presentation. Then if you sell personal data, it's also an offense. However, the law says you can be allowed to sell it if you've entered into a contractual arrangement with the data owner for their pecuniary or financial benefit. Unlawful destruction, deletion, concealment, or alteration of personal information is also an offense. If you unlawfully disclose or obtain personal data, that's also an offense. The office can write to you requiring whether an institution or an individual to comply with certain aspects of the law. If you do not comply, that failure to comply with that notice is also an offense. If you give false information in support of the application for registration, that's an offense. And if you process personal data in a country which does not have adequate measures similar to Uganda, it's also an offense. There is also one where if you process data without consent, where consent is needed, it's an offense. So what are the penalties for those offenses? One, as an organization, you can be fined up to 2% of the institution's gross annual turnover. And in an institution, every person that allowed the non-compliance to go on, you can be imprisoned between 3 months to 10 years. And the individual can even go to courts of law to seek compensation. So as you can see, the penalties are quite high. So any person dealing with data, whether as part of your AI solutions, the data sets, because you can't have an AI solution without data. So be mindful of what we just discussed. But even you as an individual whose information may be misused, please raise your voice. Don't be like this class whereby you're just keeping quiet. If you're out there and your information is being misused, you can complain to the office, yes. You're trying to give a specific example. That's an interesting one. So if you have, I'll just try to stretch your question. You have people of a particular age bracket, but then probably you want to see what the variables will be if you change and probably they're younger or older. That goes back to the purpose, because, and this is where, you know, what we call the privacy enhancing technologies come in, using synthetic data, whereby that data cannot be tied down to the individual. So if you can have data that mimics it, then you're free to do that. So that, you know, someone doesn't say, well, you told me that you will form part of this particular activity, but then you're changing it to something else. Original? If you've done what? And you declare it to be original, that no one should change it. Of course, your data is original at the time of collection. So if you're a particular age, in a particular school, and you're telling the person, please do not change it, and they go ahead to change it, to be using it, then definitely they would have gone against it. So the simple response is, yes, you can. Yours. Getting from another person. Where did you get the data from? Where did you get it from? Which sources?
So, and other websites that can give you sources of the data sets. Eh? In the event I modify that data set to suit what I want it to do, and it does it. Then let us say a company tries to link their data set to mine, but when mine is modified and I declared my modified one as my original, am I liable for fraud and legal battles?
Okay, I see the angle in which you're coming in. There is what they call intellectual property. So, and it has been very common, you know, with AI, especially with authors of books. So someone publishes even an article, then you scrap it off the website or on the internet, and then you'd like to use it as part of your data sets, and you want to change. Now, most of what you're calling fraud, they've been going under intellectual property. Because if someone scrapes someone's article, it says this is what happened, but then you show it as, let's say it happened in Europe, but it's being shown that it happened in Uganda, and changing the facts. In intellectual property, it can answer you, going back to your original. So if a person wants to change it, what you originally came up with, then there should be proper mechanisms of getting there. It's not, at that point, it's not called consent, it's called approval of sorts in regard to that data. But when you're talking about data protection and privacy, it's only in regard to personal information. You're getting it. So if you're to come up with data sets and you go, even if it's scraping from the website, visitors' books, or even dissertations of students, and you're collecting this information without their knowledge or without proper authorization, then definitely you're violating two laws: intellectual property laws and data protection and privacy, and even computer misuse. So make sure that you ensure that it's well covered. Otherwise, it will catch up with you. Yes? And ChatGPT, they are battling with those cases. Because actually, before you come in, there's a gentleman who wrote to the ChatGPT OpenAI offices, and the number, about 8 people in the when you try to put them in ChatGPT, it returns 0 because they say they cannot use their information as part of their data sets. Please go ahead.
What about in a case where one's data is available to me, but he has not protected it? I can
From where?
get it. He has kept it somewhere that is visible. Like online, he has put some clickable download button and I can access it. Am I penalized for any case of a kind?
You know, I see where people are coming from. If I'm on social media, I post pictures about me, what is happening, making my information public does not take away my data protection rights. You're getting it. And for information that is non-personal, unless the person allows you to download it for no charge, then you can go ahead and use it. But if they are not agreeable to it, then they can actually take you on. There is what they call the Creative Commons in the intellectual property laws, whereby they can tell you can download my information, but you don't have to pay me, but you need to attribute me. There are some who say you can download even if you don't attribute me, but you cannot use it for commercial gain. That is for non-personal data, but for personal data, it's mainly around making sure that it's not misused in a way to disadvantage the owner. So someone cannot pick up information, go scrape pictures of, let me say, girls of a particular age from a data set and start using it. No, that is misuse of personal information. Okay, so that's about it. I would just like to ask you to follow us on social media. We're on X, formerly known as Twitter, on LinkedIn, and then we also have a YouTube channel, all using that name, PDPO Uganda. Our physical location is PDPO at PDPO 7th floor, plot 32 Lumumba Avenue. You can reach us on email, info@pdpo.go.ug. The website, we have a lot more information. We have a resource center as one of our pages. You can find more information there, pdpo.go.ug. Those are phone contacts. We'll leave a copy of the presentation behind. Thank you. Yes, please.
Avoid like reaching the laws. I was thinking, what if use the data, it's unfair to users, but how will you?
That's a good question. And sorry, I left it
Use
out.
the data, it's unfair to the users, but it hasn't been accounted of this credit.
Lawful, you should use the data lawfully and fairly. So the law says don't use it using those particular scenarios you've given. You shouldn't use information in a way I don't expect you to use it. So that unfairness is covered in the law by that particular principle. Yes?
So, like, when collecting this data, we usually use like survey operation and in the survey operation, we highlight some. So if someone is so when I put this data on the internet, does that mean that I'm sort of right
that I'm sort of giving rights to anyone who can, because I've already told the user I'm going to put this data on the internet,
okay,
and therefore anyone will be able
which is this very principle that even if a person gives you consent, the lawful ground, does not mean that the other principles will not apply. Only upload information that is minimal for that particular purpose. And also under security, make sure under the triad CIA confidentiality, you maintain their confidentiality. So if it was a survey and what you're publishing are the results, please ensure that you don't include their names, what we talked about here. You take out their names, ID numbers, from which a person can directly identify them. You can put age brackets. Because someone may just say yes, because they think they are consenting to you getting the information, but not publication. But even if it's not clear to them, these principles guide. These principles guide that only use minimal and also maintain the security of such information. Yes. Where would you want to publish the data?
On websites like IEEE. And of course, this data belongs to certain people. Now, IEEE, I'm thinking it's a big organization. There's no reason as why they would publish the data and give us access to the data if it weren't legal. Because they know we are going to use the data to analyze and create features that are implied, that are not explicit.
So if you're relying on another party to publish that data, such as that particular organization, the law requires you that make sure that they are complying with the law. Because remember, you're not directly dealing with the person who gave them the information. That's what you're describing, isn't it? So if they have what is called a privacy notice on their website, whereby they indicate how they've ensured that they comply with data protection principles, make sure you read that. Once you read and you confirm that it's okay, then you can go ahead. Because in most instances, I want to believe they could have changed the names just to put placeholders. So if you're relying on a third party, that's how you can confirm. And if you are satisfied, then you can go ahead and publish.
So you are talking about registration with PDPO. Is there a minimum? Because I see you are talking about organizations, but let's say I'm a person and I want to do research. I have a research group of let's say 50 people. Is there like a minimum number that beyond this number you have to go for PDPO and you have to go to register, or is it as long as you're collecting personal data? Like personal data for one person. Or okay, for like 10 people. Do I have to register with PDPO, or is it like beyond like 50?
Okay, the way the law is at the moment, every person that is using personal data is required to register. But the guidance that we've been given, that the law indicates that it may gazette particular persons from being registered, but it hasn't yet been done. But if you're to use the data when people come to us on a case-by-case basis, it's mainly for your personal use. Then we don't have to register you because we don't want to mirror the NERA registration database. But in your instance, for a researcher, researchers, we've been registering them. And actually, I don't know whether here you also go to Uganda National Council of Science and Technology. Do you go there? They exempted? No, do they also go and get that approval or any guidance from them, clearance?
It depends, but most of the graduate students do go on to get that kind of rec clearance. PhD students get the clearance, most of the master students get the clearance, and some few undergraduates who are doing sensitive projects. Others mainly use open and published datasets.
I see. Then, if you're conducting research and you're collecting personal information, I think the way the law is, you're required to register with PDPO. So the guidance I would give is approach PDPO, then the PDPO will review on a case-by-case basis to see those on those that can be exempted, but those that masters, we've actually been registering them for that particular period. Undergraduate, we can review once you present your case and we see if they can actually be exempted. Yes.
side of the law, you people take the law as it's ever correct and it can never be wrong. And hence you modify it the way you want to suit your benefits. Then from our side of software engineering, for us, what is correct now can be wrong anytime, and we can modify it anytime. So, in the case I modified data, and I'm found guilty, are there loopholes that you have seen where I can survive? Then we need to also emphasize on the case of how bad can the case go to the point of destroying someone's image. Let me refer to it as the case if a civil engineer constructs a building and before finishing it collapses, surely that civil engineer will not be given a job, not so. Now, in the same case, but not failure of the system, if I make something that is viable for use, but then I violated some, that law. How bad is
Okay,
it?
I'll first start with
My side,
what you
that
said,
you guys are
the way we come up with the law, and it's in its finality, you know, it can't change. Number one, the way laws are made, especially in Uganda, there is what they call stakeholder consultations. When it's still in draft form, even starting with the ministry, because the ministry develops the law, they call people to comment, provide feedback. Even Parliament, that feedback is taken into consideration, and it's actually put in reports. The comments which are made on this particular law, the ICT committee, as it was then, it's actually available online. So people actually consulted. Lawyers do not sit in a room and just come up with the law. Secondly, can it change? Definitely laws change, they amend laws. And this one can also be amended. Now, on the question of what can go bad and then loopholes. Well, you're calling them loopholes, but I'll use this scenario as a lawyer. You know, there is a case where people are on the street. A person got a panga and cut off the other one's head. They wanted to kill the person who had done it. Police came in, they said, no, this person, right now, we need to get the evidence. Then the crowd was very bitter and said, what more evidence do you need? Everyone has seen him cut off the head, we've been recorded. Why are you wasting people's time? Well, the law is like that. Something needs to be proven. And why that person needs to be taken to courts of law? Because their side of the story needs to be heard. That person may have cut off his head because he had a defense, and the defense could be that was insane. He couldn't reason at that time, maybe he saw that person's head as a tree, and they wanted to cut the tree. So the defenses are available. That is how the law is. Going back to here, we don't call them loopholes, we call them defenses. The law says if you've done everything that the law requires of you to do, instead of fining you the 2%, imprisoning you for 10 years, you can have that as a valid defense, and then it is lowered. So you just need to make sure that you put everything in place that the law requires of you. Yes?
You guys may actually be hindering progress within this field of artificial intelligence, since people have to go through extra steps, maybe get through hoops or something. In essence, you're acting as gatekeepers to us advancing this thing faster, and we may get left behind. If so, what have you identified in this organization that could be preventing us from going further, and how do you attempt to combat it, to at least boost us so that we make relevant progress, especially in today's world?
That's a good question. You know, this law was passed in 2019, but the office was operationalized in 2021 after the regulations. before the office was operationalized, this is what was happening. Some civil society actors, they were scaring people that there is a new law, you cannot deal with data. So they created that environment of you can't deal with the data and that you only needed consent. So it brought about a situation like one that you've just described. Now, when the office was operationalized, people were hired and brought on board. Through such awareness and trainings, we made it very clear. This law is not to hinder anyone's use of data. It is to help you do it responsibly. And this is one of the unique clauses that it says if you follow these principles, and you can follow the principles through so many ways. You know, if let's say a bird needs to fly into this room, it can fly through the window, through the door. But all it needs is just an outlet. This is the law. It tells you you need to be accountable, lawful, but it doesn't tell you which one you should rely on. It gives you those so many options. And actually it makes the use of data a lot easier. You know, there is some of the things that they call the function creep, where someone says, I can develop an AI solution, but then it turns out to do something completely different, but then having harvested that data. So here it tells you that there are ways through which you can minimize that risk. Conduct a data protection impact assessment. So this law is actually to increase trust in the use of the data, not to hinder it in any way. But because so many people are not aware of what the law says, they think it is there to hinder. And our job that we've been doing is to create awareness that it is not to hinder, because even where you need data, you need to have particular safeguards to ensure it's used in the right way. And it gives you millions of options for you to do that. Yes?
We have talked about consent and also registration with PDPO.
What if,
One, for example, I have registered with,
for example, I have registered with PDPO,
when I go to the target audience, they have refused
target audience, they have refused to give me that information. Or in a case, I have gotten consent from a given person and he has given me information, I'm not registered with PDPO. So going back to the first scenario where I have registered with PDPO, but no information given to me. Then I use my own ways to get that registered.
how safe can I be?
How safe can I be? And then if they all refuse, and then maybe I get my information, but they can't I assure. Which criteria and measures have they enacted to make sure that even people who is informed, PDPO
That's a good
takes
question.
care
I
of
get a
those
sense there is an issue of data sets and getting them. Number one, registering with PDPO is just one of the accountability measures to show you comply with the law. It does not give you a green card to go ahead and collect all the information you have to. These principles need to be followed. I don't want you people to get out there and tell people, I'm registered with PDPO, so I just went and collected everything. I don't even need your consent. That principle of lawfulness. Now, your question of someone where people refuse to give you the information but use other ways, and PDPO probably is not aware, how do we protect such people? Of course, how we protect them, you know, we have a mechanism of receiving complaints. And receive many anonymous complaints. Someone says, these people are doing ABCD, so if we get you, the law will catch up with you, seeing the penalties. But what I need to encourage you, and I say it's a grave concern, you need the data, but you're struggling probably on how to get it. Find ways through which, you know, with these principles, relying on those particular mechanisms. But remember, this data could even be from other probably government offices or organizations in their privacy notices, which are the transparency documents. They actually at times allow people to get access to their data for research purposes, because we've even been giving regulatory guidance. Newspapers, hospitals, they say we have a researcher before us. They need this particular data. Then they remove the identifying areas, identifiers, and they are able to share the data where individuals cannot be identified, where it's aggregated and all that. So please continue to follow the law. Don't get data illegally. You know, the law is different from ethics, but in general data governance, there is that branch of ethics. So you engage and make sure you follow the law.
Well, from the participants online, we have about 200 of them, and I'll just pick out some of the questions that haven't been responded to. There is a question, it reads, many researchers and innovators feel financially overwhelmed by the multiple layers of compliance and registration fees required by different institutions, such as the Research Ethics Committee, the Uganda National Council for Science and Technology, and now PDPO. Has there been any discussion or policy proposal to harmonize these regulatory bodies or their processes? And what steps, if any, are being taken to reduce the financial burden on researchers and innovators, especially those operating independently or with limited funding?
Let me first take that. It's a new office, and we are increasing our collaboration to reduce the regulatory burden, and that one will take it up to see how we can, because it's government, it's one government, to see how they can be that. We are implementing different laws. We cannot say let's have one law because this law covers many other fields, but to make it easier for them, that we've been doing for other regulated parties, we'll consider that as well.
All right. The other question reads, balancing innovation, and I think this has been responded to. The other is use of open datasets or AI-generated data. If I use openly published datasets or synthetic datasets generated using AI, and I modify them for my own use, do I still need to consider data protection obligations under the Act?
Open datasets and modify. Now, one, it was the same question asked, where is the source? Because if the source, because remember you're not dealing directly with the people who provided the data, if they put that assurance guarantee, they either obtain consent, they put privacy / security measures in place, then you can go in and use the data.
Okay. And then the other question is on handling of fake or AI-generated personal data. If the data being used is fake or AI, for example, non-existent individuals, does this still fall under the scope of the Data Protection and Privacy Act? And could there be any liability concerns? And how does the PDPO assess such scenarios?
That one is not personal data, because personal data is data from which an individual can be identified. And since that individual doesn't exist, then it isn't.
All right. Okay, there's a question on okay, I'm going to come to that in a minute.
So I've just seen this one of how about mobile money agents, houses that require for our name? Are they all registered? Not all of them are registered, but we've been registering mobile money agents. Guest houses not yet, but yes, those that collect personal data, they are required to register.
Then I saw a question on enforcement, where someone said, how does PDPO enforce against, say, use the word broke or unemployed researchers, the 2%?
Enforce the 2%.
The example he gave is of a broke unemployed researcher.
Unemployed researcher, the 2%. We haven't yet reached that stage, but if we get that unemployed researcher who misuses personal data, then we can test the law with them, because that's what the law says. And by the way, that 2% is imposed by courts of law, not PDPO. PDPO just makes a case and it's given to courts of law for determination. Yes.
There's a law about
change. Yes, it does. When a person changes or withdraws their consent, actually what we call withdraw, you cannot rely on that information. And like I indicated, consent is not the only ground that you can rely on process personal data. So you need to look at the law and see which one best applies for you or for your circumstances. We have, I think we can give it probably 5 more minutes and then we conclude.
You talked about internship opportunities and research. I was wondering that since you're working with personal data, that means you can't just recruit interns like that. So do you make them sign NDAs so that you can keep their personal data like private?
Yes, they do. And actually not just interns, everyone. It's a company policy.
Then to conclude, the last question will be the one on prisoners, as brought up by Marvin. I don't seem to find it, but it was about prisoners' data, seeing that they are under custody and it's the prison's authorities responsible for their data. How do they give consent if anyone would want to access it?
The researchers?
Prisoners, seeing that they are under custody of the authorities and their data is kept by those people. Accessing such data would require that you have their consent. So how does one go about such scenarios?
Say a researcher wants to conduct research on prisoners.
Right.
Now, of course, the prisoners are under the custody of the prison system, that is Uganda prisons. So they go through that and they see if they can access them. Okay, that's about it. Eventually, the class became active towards the end. Oh, sorry. Okay, I think we've responded to most of them, but is there one which we haven't responded to?
We've looked at most of them. They're there, but you had responded earlier.
In different formats. Huh? Okay,
Yes.
but it doesn't stop here. If you have questions, you can send your questions to us, info@pdpo.go.ug. And we give you further guidance. I've seen most questions have been around accessing data sets, change, even after accessing and how you go about it. That is something that we'll definitely be looking into. Our curriculum on data protection and privacy will be rolled out sometime next year. I encourage you people, even when you're done with school, to enroll. We are talking about data protection and privacy, and someone is taking my photo without my consent. They did indicate. Anyway, so thank you for being attentive. At least I think it's probably how you learn. Most of you were actually picking up the lessons, but you're not expressive, but you picked up towards the end. The law is here to help you. It's not to bar you from doing your work. It's not to stop your innovations of AI. So if you have any question, please send it to info@pdpo.go.ug. We guide you and you don't get the data illegally. That's why the office was established, to do exactly that. I'd like to thank Mr. Ggaliwango for inviting us, and we would like to end here. Thank you very much.
Nadia team online.
Oh, sorry, just something. We, we are going to take back these books because the class was so silent. But since people started asking questions, we carried copies of the law and some notebooks. There are not so many, so.
I don't know.
We can give the people who are active.